Hello everyone, I'm Shogo Yamagami, an attorney at law in Japan. This time, I would like to introduce how to obtain parental rights in Japan while you get a divorce. However, this issue is related to Japanese legal practice only. It is not related to the Hague Convention issues. By the way, we have another video about 3 important points of divorce in Japan. So if you have time, please watch it. Parental rights include a custodial right, rights to decide children's education, health, residence, and so on. But in many cases, the custodial right is most important for both parties. And the custodial right means that which of spouses has a right to live together with his or her children after divorce. Japan does not have a joint custody system, only has a sole custody system. So both spouses need to decide which of spouses has parental rights after they get a divorce. In case that both spouses cannot reach an agreement to decide it, I think that they need to bring the case to a court to be decided. And, for example, both spouses live in Japan and one of the spouses is Japanese national, they can bring the case to a Japanese family court and Japanese laws shall be applied to the case. Japanese family court has some standards to decide this issue, so I'd like to introduce such standards. Number 1. Which spouse mainly takes care of their children? This standard is considered as the most important thing by the Japanese court. So I think it has been traditional in Japan that a father works outside and the mother takes care of children. So there were many cases so far in Japan that finally the mother obtained parental rights after divorce. But if a father mainly takes care of children, he has a chance to get parental rights and custodial rights of his children. Of course, evidence is needed to prove this fact. So pictures or movies of children's daily life, a diary describing how you have taken care of children, etc., are considered as evidence. Number 2, will of children. In court case, an investigator of family court will have an interview and confirm the will of children. However, it is not an absolute standard because generally speaking, a younger child tends to listen to the wish of the one spouse to whom he or she lives together with. Number 3, no separation between brothers and sisters. This standard means that brothers and sisters need to live together if possible. Number 4, situation of initiation of custody. If one of the spouses forcibly takes the children from the other spouse to start custody, this fact is not in favor of the taking spouse. Number 5, whether he or she allows the other spouse's visitation of children. For example, if one of the spouses does not allow the other spouse's visitation of children for a long time, even though the other spouse pays child support continuously, this fact is not in favor of the spouse who currently takes care of children. Number 6, whether there are supporters to take care of children. One of the spouse's parents of children's grandfather and grandmother are examples of supporters. Number 7, the mother's priority. But in Japan, it is not so important. Number 1 above is more important. Number 8, other standards. Japanese courts also will consider policy and environment of education, daily life of children, and so on. Of course, the spouse who abuses children cannot obtain parental rights. Japanese family court will take every standards above into consideration to decide which party has parental rights of children. Thank you for watching.